Rasmus Munk Søndergaard, attorney at law. I specialize in human rights and freedom of speech issues. I wish to offer my legal opinion about the judgment of the journalist Tommy Robinson, who was sentenced to 18 months of prison on October the 27th for illegal speech. I wish to be absolutely clear. As a human rights specialist, I think this judgment is a gross miscarriage of justice and a flagrant violation of the right to freedom of speech and protection of journalists. As such, this judgment is a threat to the very essence of free and democratic societies based upon open and truthful deliberation. The functioning of the judiciary, indeed the functioning of Western society itself, fundamentally rests on public confidence in judges to act as steadfast guardians of justice within the legal system. For this confidence to exist, lawyers like myself must have the freedom to criticize and comment on the administration of justice in the legal system. This is provided that the lawyer does so consistently with the honor and dignity expected from advocates as servants of justice. Thus, a lawyer may not gratuitously attack a judge, proffer insults, or merely seek to publicly settle the score after having received a negative decision. No such conditions exist for myself, so with these limitations in mind, here are some background facts about the case. The case initially arose after Robinson made statements about Jamal Hijazi, who had been involved in an altercation at a British school in 2018, which had sparked a heated national debate after a video of the fight went viral. National media outlets seized upon the video and condemned it as a racist attack by a hateful native Briton on an innocent, vulnerable refugee boy. The attacker in the video, a 16-year-old schoolboy, was even called vermin by media star Piers Morgan, who called for severe retribution against the child.
Everybody was exposing the scumbag that did this, who I hope gets severe retribution.
The case had now become a matter of national politics and racism in Britain, merely because of the ethnicities of the children involved. As a journalist, Tommy Robinson went against the overriding media narrative and contended that Hijazi was not quite that innocent, but that he had been part of a gang, had been violent, and caused bodily harm to girls in the school. According to Tommy, Hijazi might have brought the attack upon himself through his own bad behavior. Hijazi sued Robinson for his statements, leading to a judgment where Robinson was found guilty of libel. He was ordered to pay £100,000 in damages plus legal costs of his opponent. You can find the text of the judgment in a link below. Before the judgment, Tommy had threatened to go public with evidence of the misbehavior he was alleging. To this, the court responded by laying down an injunction, a court order, seeking to prohibit Robinson from reiterating specific statements about Hijazi that were held by the court to be defamatory. This on the threat of being found guilty of contempt of court if he did not obey. The specifics of the court order can be seen in the judgment to imprison Tommy for 18 months. Again, I will link this below. According to the judgment, the injunction had the following terms. The defendant must not, whether by himself, his servants, agents, or otherwise howsoever, publish or cause or authorize or procure the publication of the following allegations or any similar allegations in relation to the claimant. 1. That the claimant had, as part of a gang, participated in a violent assault on a young girl which had caused her significant injuries. 2. That the claimant had threatened to stab another child. 3. That the claimant had bullied a child referred to in the judgment as BWI. 4. That the claimant had behaved in an aggressive and bullying manner towards girls and women. 5. That the claimant had a propensity towards using or making threats of violence against other pupils at Almondbury Community School, and or that the claimant had attacked and injured a pupil at Almondbury Community School with a hockey stick. While Tommy initially bowed before the threats of the court and refrained from speaking on the matter, he did not remain silent.
The documentary you're about to watch is the most important documentary I've ever made. This story is far bigger than Tommy Robinson. This is about the weaponisation and the politicisation of these buildings. Court buildings across the West. the Royal Courts of Justice, ironically named. These buildings have been weaponised and used against members of the public to destroy them if they speak out. From Donald Trump to Steve Bannon, to Geert Wilders, to Marie Le Pen, to Katie Hopkins. That's what's happening. My job as a journalist, I stand for freedom of speech, I stand for freedom of the press. And I failed, because 3 years ago when I lost a court case in here, and they bankrupted me to the tune of £1.6 million, on a documentary, you're going to see the entire story was a lie, okay? I failed because I should have come out of court and I should have played you that film. Why didn't I play you that film? Because I was given a gagging order by this building, by this judge. I was silenced, and I allowed them to silence me. Because I was scared. I was scared of 2 years in prison. I was scared of the effect that solitary confinement for that length of time would have on me. I was scared of jihadi gangs in jail. And I was scared of the effect it would have on my family. I failed me and I failed you. I'm not going to fail myself again.
Robinson is a close friend of the Danish Free Speech Society, whom I have been greatly honored to have represented in court. The Free Speech Society, along with the Danish People's Party, had invited Robinson to Christiansborg Palace in Copenhagen, the seat of the Danish Parliament, where he premiered the documentary Silenced, in which he presented evidence relevant to the defamation case and criticized the media and the judicial system.
Good afternoon and welcome to the world premiere of Tommy Robinson's latest documentary, Silenced.
The video is still pinned on Tommy's Twitter profile and you can find it in a link below. I urge you to watch it for yourself and ask yourself if you think the original defamation judgment seen is reasonable. I shall return to this later in this video. Robinson is being sentenced to 18 months imprisonment for sharing this documentary and talking about it on different occasions, because the court held that these were violations of the injunction and constituted contempt of court. But is Tommy even guilty of contempt? The British legal system contains a moral hazard in that it greatly rewards admissions of guilt when laying down punishment. Defendants are more harshly punished if they uncompromisingly contest their innocence. I quote from the decision: "Where the contemptor has admitted the contempt and entered the equivalent of a guilty plea, that may justify a reduction in the sanction imposed." As I have not been involved with the case, I cannot say if Tommy Robinson admitted to being guilty of contempt of court for this reason. While the injunction barred Robinson from making specific claims about Jamal Hijazi, it is not clear to me that he has specifically made such statements. In the decision about contempt, it is held that on 10 separate occasions he violated the injunction. I have investigated the documentary Silenced as well as the YouTube video where Tommy appeared with Jordan Peterson the 30th of June, which are both mentioned by the court as instances of violation of the injunction. I have not found any instances of Tommy explicitly stating anything about Jamal Hijazi. Instead, I have heard him criticizing the judgment and insisting that he was punished for saying the truth. If it is the case that Tommy has not explicitly stated anything about Jamal Hijazi, but that we are talking about sharing of evidence and witness testimonies about the court case, as well as Tommy's insistence on his own innocence and victimhood of judicial misconduct, I cannot then see that this actually violates the terms of the court order as it was laid down. This means that he would not be guilty and was thus wrongly convicted. If the court order functions as an open-ended gag order, which is how it appears to me, I must insist that this directly violates Article 10 of the European Convention on Human Rights that protects freedom of expression. Here it is. Article 10 of the Convention, freedom of expression. Everyone has the right to freedom of expression. This right shall include freedom to hold opinions and to receive and impart information and ideas without interference by public authority and regardless of frontiers. This article shall not prevent states from requiring the licensing of broadcasting, television, or cinema enterprises. 2. The exercise of these freedoms, since it carries with it duties and responsibilities, may be subject to such formalities, conditions, restrictions, or penalties as are prescribed by law and are necessary in a democratic society, in their interests of national security, territorial integrity, or public safety, for the prevention of disorder or crime, for the protection of health or morals, for the protection of the reputation or rights of others, for preventing the disclosure of information received in confidence, or for maintaining the authority and impartiality of the judiciary. This text is rather open-ended, so to understand the legal specifics of the human right to freedom of expression in Europe, recourse must be had to the case law of the European Court of Human Rights, which has the authority to pass binding judgments about the Convention vis-à-vis European states. The Human Rights Court is thus tasked with finding fault with the decisions of national judges relating to cases involving human rights, such as freedom of expression.
Most people, if you presented them with ECHR, wouldn't actually know what it is. I think there is a growing concern that in Brexit Britain, a court in Strasbourg still has a say. Just a quick potted history. This European Convention on Human Rights, the court in Strasbourg, this was done to stop abuses such as were going on in Austria and Germany in the early 30s. It was with good intentions, wasn't it?
It was, and what it does is it protects the individual from unlawful interference by the state. I mean, it'd be interesting to know what parts of the convention people don't agree with. I'll give you one, the right to life. Do you agree with that one?
Do I agree that I need some European convention giving me the right to life? No, they can go to hell. I've got those freedoms in my own country.
Freedom of expression, do you agree with that?
I don't... No, Ivan, here's the point. This is my point. I don't think we need a European convention to give it to us. Whatever the imperfections of our country, we have, I would argue, since Magna Carta, actually lived in the freest of all European countries. Why do we need this stuff to be given to us?
Because you can't have a government with unfettered rights against citizens. You need to have some protection for individuals.
Okay,
and that must be built into a democratic society. You can't have, otherwise we would live in some sort of dictatorship. And you don't have these rights in China or Saudi Arabia. And there's a reason you don't have these rights.
But this is the United Kingdom.
Regarding the court order and its compatibility with freedom of expression, I therefore refer to the official guide to the case law of the European Court of Human Rights on Article 10. I quote, "The court is particularly attentive to the censorship aspect of an interference and must be satisfied that the penalty does not amount to a form of censorship intended to discourage the press from expressing criticism. Hence, the conviction of a journalist prior to publication amounted in the court's view to a form of censorship that was likely to discourage him from undertaking research inherent in his job, with a view to preparing an informed press article on a topical subject. The court is described as censorship an order suspending the publication and distribution of newspapers which it considered unjustified even for a short period. Similarly, an injunction forbidding a painting from being exhibited and photographs of it being published, and which was not limited either in time or in space, was found by the court to be disproportionate to the aim pursued with regard to the relevance of the passage of time in assessing proportionality. But how else can the injunction be interpreted if not aiming to censor the speech of Robinson and restricting publication of his ideas? The notion seems absurd. But this broad and sweeping interpretation of the injunction even seems to incompatibly contradict that very judgment sentencing Tommy to 18 months imprisonment itself. I quote from the judgment. "In a democratic society underpinned by the rule of law, court injunctions must be obeyed. A party who has lost a case is entitled to appeal, or to disagree with the result, or to criticize the decision, but they are not entitled to disobey a court injunction." But did Tommy not do just that? Disagree with the court result, and then providing a very thoroughgoing criticism of the court decision. In the judgment, the judge spends no time to demonstrate that he is consistently applying his own principles to the case. For not to be a censorious and blanket prohibition of speech and be consistent with freedom of expression, the terms of an injunction must be given the most narrow interpretation as possible. Therefore, until I see specific evidence of specific violations of the actual terms of the injunction, I hold that Tommy is wrongfully convicted and is innocent of contempt of court. Moving on to the original defamation judgment. Was it just? I think there is ample room to question whether Tommy was indeed given a fair trial during the initial defamation case. In the documentary Silenced, Robinson is able to show numerous people who on hidden camera agree with the substance of his assertions about Jamal Hijazi. What is the correct standard, then, for judging guilt of defamation involving the press and issues of public debate? The European Court of Human Rights, in its seminal judgment called Bladet, Tromsø and Stensaas, held the most careful scrutiny on the part of the court is called for when, as in the present case, the measures taken or sanctions imposed by the national authority are capable of discouraging the participation of the press in debates over matters of legitimate public concern. Article 10 of the Convention does not, however, guarantee a wholly unrestricted freedom of expression, even with respect to press coverage of matters of serious public concern. Under the terms of paragraph 2 of the article, the exercise of this freedom carries with it duties and responsibilities. By reason of the duties and responsibilities inherent in the exercise of the freedom of expression, the safeguard afforded by Article 10 to journalists in relation to reporting on issues of general interest is subject to the proviso that they are acting in good faith in order to provide accurate and reliable information in accordance with the ethics of journalism. In the case, the journalist had relied on an official report to allege that crew members of a seal hunting ship had illegally flayed seals alive. Norwegian courts had then found them guilty of defamation, but the Human Rights Court held that the judgment of the Norwegian court was a violation of their journalistic freedoms and the right to freedom of expression. Thus, the legal test to be applied was whether journalists had been unreasonable in relying on an expert report and whether this was sufficient to verify the information they published. Did they act in good faith? Nowhere in the defamation case has the court investigated whether Tommy Robinson acted in violation of the ethics of journalism or whether the statements he made were in good faith. How would they not be when several people had affirmed to him that it was true that Mr. Hijazi had indeed acted as Robinson alleged? I quote again from the official guide. The court reiterated that if the national courts apply an overly rigorous approach to the assessment of journalists' professional conduct, the latter could be unduly deterred from discharging their function of keeping the public informed. The courts must therefore take into account the likely impact of their rulings, not only on the individual cases before them, but also on the media in general. In the ruling, there was no regard had in the account of Judge Nicklin as to the effect his ruling would have on the media. Neither is there in the prison sentence for contempt. Again, the guide says, the court considered that allegations in the press cannot be put on an equal footing with those made in criminal proceedings. Nor can the courts hearing a libel case expect libel defendants to act like public prosecutors or make their fate dependent on whether the prosecuting authorities choose to pursue criminal charges against and manage to secure the conviction of the person against whom they have made allegations. But did Judge Nicklin not demand just this kind of standard? That Robinson acted as a prosecutor, proving beyond any reasonable doubt that Jamal Hijazi had himself been violent, and that all evidence presented before Judge Nicklin to this effect was easily dismissed. I refer you to a thoroughgoing analysis of the judge's treatment of evidence in the case, and it is linked below. The guide then goes on to say that the Human Rights Court holds that the presumption of falsity can be seen as unduly inhibiting the publication of material whose truth may be difficult to establish in a court of law, for instance because of the lack of admissible evidence or the expense involved in doing so. The court emphasized that the reversal of the burden of proof operated by that presumption makes it particularly important for the courts to examine the evidence adduced by the defendant very carefully, so as to not render it impossible for him or her to reverse it and to make out the defense of truth. It considered that journalists may be relieved of the obligation to prove the truth of the facts alleged in their publications and avoid conviction by simply showing that they have acted fairly and responsibly. Once again, there was no test whether Robinson had acted fairly and responsibly as a journalist. I assert that the judges in both cases failed to correctly administer their duty to consider Tommy's cases in line with correct legal precedent regarding the human right to freedom of speech. The judgment finding guilt of contempt lists those legal principles that the judge is aware of that should guide what sanction could be imposed for contempt of court. And I quote, "The sanction imposed for a contempt should, where possible, not be manifestly discrepant with the appropriate sentence in criminal proceedings for equivalent conduct." But the conduct that in itself constitutes the very breach of the injunction is allegedly repeating defamatory statements. But the imprisonment of journalists for defamation is in itself extremely suspect and a practice that is condemned across Europe as profoundly abusive. In 2007, the Parliamentary Assembly of the Council of Europe adopted Resolution 1577 titled Towards Decriminalisation of Defamation. It thereby vehemently protested the unacceptable and abusive practice of imprisoning journalists for defamation by state power. I quote, "The Parliamentary Assembly, recalling its recommendation on freedom of expression in the media in Europe and its resolution on threats to the lives and freedom of expression of journalists, unequivocally reiterates that freedom of expression is a cornerstone of democracy. Where there is no real freedom of expression, there can be no real democracy." The Assembly states from the outset that the press plays a fundamental role in promoting debates on issues of public concern, and debates of that kind, as open as possible, are vital to democracy. The Assembly draws attention to its resolution on the ethics of journalism and emphasizes that those who exercise the right to freedom of expression also have duties and obligations. They must act in good faith and provide accurate, trustworthy information in compliance with journalistic ethics. As established in the Caselaw of the European Court of Human Rights, Article 10 of the European Convention on Human Rights guarantees freedom of expression in respect not only of information or ideas that are favorably received or regarded as inoffensive or as a matter of indifference, but also of those that offend, shock, or disturb. The Assembly notes that freedom of expression is not unlimited and that it may prove necessary for the state to intervene in a democratic society, provided that there is a solid legal basis and that it is clearly in the public interest, in accordance with Article 10, Paragraph 2 of the European Convention on Human Rights. Anti-defamation laws pursue the legitimate aim of protecting the reputation and rights of others. The Assembly nonetheless urges member states to apply these laws with the utmost restraint, since they can seriously infringe freedom of expression. For this reason, the Assembly insists that there be procedural safeguards enabling anyone charged with defamation to substantiate their statements in order to absolve themselves of possible criminal responsibility. In addition, statements or allegations which are made in the public interest, even if they prove to be inaccurate, should not be punishable, provided that they were made without knowledge of their inaccuracy, without intention to cause harm, and their truthfulness was checked with proper diligence. The Assembly deplores the fact that a number of member states' prosecution for defamation is misused in what could be seen as attempts by the authorities to silence media criticism. Such abuse, leading to a genuine media self-censorship and causing progressive shrinkage of democratic debate and of the circulation of general information, has been denounced by civil society, notably in Albania, Azerbaijan, and the Russian Federation. The Assembly concurs with the clear position adopted by the Secretary General of the Council of Europe, who has denounced threats of prosecution for libel as a particularly insidious form of intimidation. The Assembly views such aberrant use of anti-defamation laws as unacceptable. The Assembly also welcomes the efforts of the representative on freedom of the media of the Organization for Security and Cooperation in Europe, OSCE, in favor of decriminalizing defamation and his unfaltering commitment to media freedom. It notes with great concern that in many member states the law provides for prison sentences for defamation and that some still impose them in practice, for example, Azerbaijan and Turkey. Every case of imprisonment of a media professional is an unacceptable hindrance to freedom of expression and entails that, despite the fact that their work is in the public interest, journalists have a sword of Damocles hanging over them. The whole of society suffers the consequences when journalists are gagged, by pressure of this kind. The Assembly consequently takes the view that prison sentences for defamation should be abolished without further delay. In particular, it exhorts states whose laws still provide for prison sentences, although prison sentences are not actually imposed, to abolish them without delay so as not to give any excuse, however unjustified, to those countries which continue to impose them, thus provoking a corrosion of fundamental freedoms. The Assembly likewise condemns abusive recourse to unreasonably large awards for damages and interest in defamation cases and points out that a compensation award of a disproportionate amount may also contravene Article 10 of the European Convention on Human Rights. It is amply clear that the European community at large condemns in the sharpest terms the imprisonment of journalists for defamation. This is not some obscure pronouncement from a powerless international body, for the European Human Rights Court has frequently referred to this very resolution in its judgments. I quote from the official guide. In this connection, the Court has frequently referred to Resolution 1577/2007 of the Parliamentary Assembly of the Council of Europe, which exhorts states whose laws still provide for prison sentences for defamation, although prison sentences are not actually imposed, to abolish them without delay. Going on to say, the Court pays considerable attention to the severity of a criminal penalty in defamation cases, particularly where a matter of public interest is involved. In this connection, it is reiterated that the imposition of a prison sentence for a press offense will be compatible with journalists' freedom of expression as guaranteed by Article 10 of the Convention only in exceptional circumstances, notably where other fundamental rights have been seriously impaired, as, for example, in the case of hate speech or incitement to violence. See also a case where the court described the prison sentence of 2 years and 6 months imposed on the applicant as grossly disproportionate and instructed that he was to be released immediately. In the case of Robinson, there were no calls for violence against Jamal Hijazi. There was no hate speech directed against him. A prison sentence for defamation simply cannot be justified. But just how hostile is the Human Rights Court against the use of criminal sanctions against journalists? Even the mere sanction of a symbolic €1 fine is viewed as suspect, and I quote, "In cases involving the press, the court has held that the criminal law nature of the penalty is more important than the minor nature of the penalty imposed." This reasoning is also found in other cases where the court reiterated that even when the sanction is the lightest possible, such as a guilty verdict with a discharge in respect of the criminal sentence and an award of only a token euro in damages, it nevertheless constitutes a criminal sanction. To quote the judgment about contempt, an 18-month prison sentence is manifestly discrepant with the appropriate sentence in criminal proceedings for defamation, and it cannot be upheld. Tommy Robinson should therefore be released immediately. I am appalled to see that the United Kingdom judges against Tommy Robinson seem to have had absolutely no regard to issues of freedom of speech and their obligations to consider defamation cases in the light of the jurisprudence of the European Human Rights Court. The failure to consider the jurisprudence of the Human Rights Court can in itself be a violation of the Human Rights Convention and its guarantees of the right to a fair trial. This falls in line with my own experiences as a lawyer, where it is my contention that judges have an ingrained tendency to avoid taking seriously human rights if these can be viewed as favoring right-wing political issues. The human rights system emerged as the answer to the devastation of a world torn apart by world war and ethnic hatred. It was built to be a bulwark against oppression, designed to heal the wounds that scarred nations and families alike. As the Human Rights Court affirms, there can be no democracy without freedom of speech. If the individual cannot speak freely, he cannot truly be the locus of political sovereignty. The right to express ideas, opinions, and dissenting, however uncomfortably, is the very bedrock of human self-determination. Freedom of speech empowers the individual to stand as a dignified participant in society, sharing in creative authority over the world, and entrusted with the responsibility to hold power to account. This right upholds the nobility of the individual, not as a passive recipient of truths dictated from arbitrary power, but as a mature, adult creature, responsible for engaging with the world, questioning it, and learning from it. It is this sovereign freedom that democracy demands and that true justice requires. If European judges allow the human rights system to become a farce, where only rights that benefit a political left wing are enforced, they will destroy the moral foundations of the entire convention system, meant to keep together what was torn asunder. The system meant to secure rights universally is at serious risk to become a tool of selective justice, neglecting the rights of native Europeans while protecting only narrow political perspectives. A system blind to the rights of citizens based on ethnicity and skin color. If judges persist in such partiality, the convention system will eventually fail to fulfill its intended purpose as a guardian of true justice and the dignity of the individual. The system will have been killed through hypocrisy. In his treasured speech on the liberty of the press, Areopagitica, John Milton, the greatest English poet, wrote, "Who kills a man kills a reasonable creature, God's image, but he who destroys a good book kills reason itself, kills the image of God as it were in the eye. Many a man lives a burden to the earth, but a good book is the precious lifeblood of a master spirit, embalmed and treasured up on purpose to a life beyond life. 'Tis true, no age can restore a life whereof perhaps there is no great loss, and revolutions of ages do not oft recover the loss of a rejected truth, for the want of which whole nations fare the worse. We should be wary, therefore, what persecution we raise against the living labors of public men, how we spill that seasoned life of man, preserved and stored up in books, since we see a kind of homicide may be thus committed, sometimes a martyrdom, and if it extend to the whole impression, a kind of massacre, whereof the execution ends not in the slaying of an elemental life, but strikes at that ethereal and fifth essence, the breath of reason itself, slays an immortality rather than a life." But the European human rights system is not a single book wrought from the genius of one single man. It is the product of over 50 years of collective European effort by the brightest minds of each of our nations. An astoundingly monumental enterprise driven by countless judges, lawyers, victims of injustice, ordinary citizens from all corners of the continent. It is the legacy of lives lost and dreams crushed, of people who suffered oppression and injustice, and the ingenious efforts to shine the light of law against that darkness. These sacrifices, that immense human cost, fueled the wisdom of the Convention's jurisprudence, enshrining a painstaking edifice that would elevate justice across Europe and protect individual sovereignty against state overreach. A commitment to learning from the dark chapters of our past, to building a society where every person, regardless of their nationality, is entitled to dignity, justice, and an individual voice of conscience. If this precious inheritance is abandoned, it would be the most profound betrayal of the very spirit of law, a spirit that countless individuals gave their lives to uphold. What greater loss could there be than to watch this collective dream slip back into the black hole of oblivion, struck down not by necessity, but by the complacency and hypocrisy of those entrusted to protect it? Tommy Robinson should be released immediately, or the foundations of European unity are already dead.
Freunde, nicht diese Töne, sondern lass uns angenehmere anstimmen und schöner Götterfunken, Tochter aus Elysium. Wir betreten feuertrunken, himmlische dein Heiligtum. Deine Zauber binden nieder, was die Mode streng geteilt. Alle Menschen werden Brüder, und ein sanfter Frieden